The Privacy Act 1988, as amended. The Privacy Act 1988 is an Australian Commonwealth law that was developed by the government in order to protect information related to individuals. The law was developed in order to keep individuals' private data and PII safe, as well as outline to organisations their responsibility in handling all their employee and client data in relation to privacy. So it's made to keep people's data safe, and it tells organisations you're responsible for keeping information safe. You need to have measures in place so that the data on your system is not accessed by any unauthorized parties. Now, a specific of this legislation is that of the privacy principles. Okay, and there are 13 principles it goes over in relation to data protection. Now, I'm not going to go through the 13 principles, but I will go through a summary of the 13 principles. Okay, so firstly is that the data in the manner that it is collected, the way it is used, and that it is of quality. And when I say of quality, it is accurate and up to date. Okay, so data needs to be of quality, okay, when obtained, used, and stored on a system. Now, that means ensuring data is correct. Now, we do that at the point of collection. We have validation measures in place and verification measures in place. But over time, data may change. People might change phone numbers or where they live, addresses. So we need to ensure that we keep our data up to date. We send out forms to make sure that data that might have changed, if it has changed, we update the data on our end too, and it's kept up to date too. We have a responsibility to do that in line with the privacy principles. The next level is that about the organization's accountability in maintaining privacy. Organizations need to have procedures in place to keep data secure from unauthorized access. So they've got to be putting in place procedures such as login procedures and access rights within their own organization, because it should even be private within the organization. Not everyone has the right to view data stored on a system. Okay, it should only be for specific members whose job tasks the actual data aligns to. So organizations are accountable in maintaining privacy. It's when too many people have access to data that problems occur and leaks can potentially occur, mistakes can be made, and then suddenly unauthorized access is granted by potentially an external body. The next level is that of disclosure, okay, specifically of personal information to other parties. Do organizations have the right to share information with other parties? Now, the safe answer is no. They should not be sharing data in line with privacy, but there may be cases when they do have the right to, when it may be relevant, or if they are going to do that, they might have to ask permission from the individual who the data is stored about, that this data needs to be shared with another department in order to follow it up. The other thing to be careful of is when people sign up to a specific organization service, they may have listed in their terms and conditions this data will be shared for marketing and tracking purposes. Okay, so you do have to be aware of that with what you sign up to, because when you sign up to things, you are giving away your PII, your personal details, potentially financial details, your emails, and okay, things like that. So just be aware of that, okay? And that will be written probably very small in a very long terms and conditions. And then finally, individuals have the right to access their information that is stored about them on an organization system, particularly in government systems. And this is the purpose for ensuring that that data about their personal information is correct. So they can check it and they have the ability to correct it themselves or apply for it to be corrected if the data stored about them is incorrect. Okay, so you have the right to see information stored about yourself on a system. So flowing on from that, okay, the Privacy Act puts this obligation on organizations, okay, enabling individuals to access data stored about them on their system. Okay, so individuals have the capacity to view the data that is stored about them on a system, to amend the personal information that may be incorrectly stored about them on the system, and update it on the organization system. So individuals need to have an ability to access their data stored on an organization system, and really only their data, okay, but they have the right to see it and update it if need be. So I hope this video has given you an understanding of the Privacy Act 1988, how it was made to protect the privacy of individuals when organizations are storing information about different people, how there are 13 privacy principles, although we did summarize them here. They're related to the use of collection, use, quality of data, okay, and how data is stored on a system, how organizations are accountable for maintaining privacy, how there are rules around the disclosure of information to other parties, and that data stored on systems should be correct. and how individuals are allowed to view data stored about them on the system, and organizations are obliged to provide the tools for actual individuals to check their data stored on the system. And if it is correct, they have the ability to update the information and ensure their data is correct stored on a system. So that's just a brief overview of the Privacy Act 1988, and I hope it gives you just a bit of an understanding of what it's kind of covering in relation to privacy.